that promises to be very interesting and engaging. As practitioners, one of the instances where we encounter obstacles in our practices will be occasions where you need to take practical decisions to resolve issues for your client and decide whether it is a matter you should spend lengthy time on litigation or other means of dispute resolution, or whether it is one that could be resolved amicably. This is a specialized area of practice, and we have seen that through the many rules of courts and other institutions, you will see the issue of alternative dispute resolution cropping up in all of them. We have somebody who is very capable. Dr. Ushato is going to delve into this issue, and as we go along, we'll be able to see what he has in stock for us, and then we'll be able to ask questions that will answer other issues we might have relating to this topic, when to negotiate and when not to do that. We also have other persons who are not speaking today, but they are panelists. We have Leonard Senior Advocate and Nan Wilson. And as time goes on, if there are needs for any other of the panelists who are present to chip in, we'll be able to do that as we go along. Please, Doctor, you have our attention. Please proceed.
All right. Okay. Good afternoon, ladies and gentlemen. Let me begin by, again, paying my respects to my lords who are here present, learned silks, learned colleagues, my brothers and sisters. I want to say that it's a great pleasure and privilege to have been given this role, like Oke mentioned, to lead a discussion on the area where perhaps as we move on, we will see that there are potentials and great opportunities for all of us. Let me, in order to save time, begin by sharing my screen. Okay, can you confirm that you are seeing my screen?
Clearly, very clearly.
Okay. And confirm that it is moving?
Yes, yes, please.
All right. Thank you very much. Now, the topic for our discussion today will center on when to negotiate and when to fight. Here we're using fight to represent any other thing other than what we shall describe as negotiation. And to guide us in this discussion, permit me to just say a few things by way of roadmap. A few comments by way of upfront positions I want to take. We shall talk about the new world that has suddenly come upon us, not just because of COVID, but that it had always been with us. Some few definitions for purposes of academics. We shall now isolate some moments of history, historical watersheds, and look at how some great men, people like all of us gathered here, how they took the decision as to whether to negotiate or to fight. Here, we are going to have what we call benefit of hindsight. At the time they were making those decisions, they were not in a comfortable position that we are in today. And therefore, though we are going to judge them, but we are not judging them from the point of view of right or wrong, but that because we are now in a privileged position to look back, we can say, oh, they should have done this or that. But if we were in their shoes, we probably would not have done better. And then finally, we shall zero in on the main issue of when should we really negotiate and when should we go on and fight. Just a few words by way of conclusion. So Ladies and gentlemen, this will represent the roadmap for today. Permit me to begin by borrowing from what the learned counsel did when he was faced with the kind of situation I have today. A situation that is a bit difficult, and for me, because of the audience. And therefore, this learned counsel started by making this comment. In defending my clients against the charges of defamation, I will show that the words were not said by Mr. John, who happens to be the client of this our learned colleague. Or if they were said by him, then the particular offending word was not. Or if it was, then Mr. John did not mean them in the plaintiff sense. Or if he meant the words in the defamatory sense, then the words had substantial truth. Or if they had not, then my client, that's Mr. John, could not at the time he said them, know them not to be true. Or if he did, he could not then and cannot now know them to be untrue. Or if he can and could, and he could and did, and they had not and he did, and they were and it was, then my client is not Mr. John. My learned friends, please, this is what you put in for me. If at the end, it turns out that in trying to navigate this dangerous route, I did not perhaps take due cognizance of all the landmines. There is one authority in this area that will never mislead you. And this authority is known by the name Chester Karas. In the field of negotiation, he will never mislead you. And therefore, whenever you see his works, please go through them. There is a comment he would always make concerning the area we're dealing with. And the comment is to the fact that both in business and in life, you may not get what you deserve. Life is very unfair. You hear those comments. Well, he clearly asserts, you will always get what you negotiate. In fact, that if you negotiate well, you may get more than you deserve. And therefore, the key word here, negotiate. Because that guarantees you that you will land at a particular point, or you may even do better than you thought you could. Newsweek magazine famously said that the use of the word negotiation is an oversimplification of reality. Why? That we are actually dealing with what they called a game of life. The reason being that both in life and in business, there are vast areas of legitimate conflicts. That is, the conflict itself is legitimate, and therefore you need to play to win. And negotiation offers you this opportunity. However, because it is a game, I mean, you don't win premiership unless you're both strategic and tactical. And therefore, to play to win, negotiation is key. However, Chester Karas has introduced a new variable. What is this variable? He said that today we are actually playing in what he had described as the new world. New world has suddenly come upon us. not only through COVID, but through other forms and aspects of introductions that came through globalization. In fact, there is a book I'm always fond of. The title is Geography is Dead, written by Brian. However, Chestakara said for our education, we must recognize that the characteristics of this new world is that it can be summed up as being composed of what we call parallel and multiple complexities. We will come back to this, but please mark these words: parallel and multiple complexities, both in business and in life. However, the new world is transiting from just being complicated to be what? Complex. We'll leave this here and we'll come back to it. And you see why the significance for our topic of discussion. So, what do we mean by negotiation? Again, you can get various academic definitions of negotiation, each of them valid. But when we strip all the definitions of the niceties, you will get to the point where you find the real essence of negotiation, that it is nothing other than communication for the purpose of reaching an agreement. By communication here, we are referring to dialogue that is both politically, culturally driven. And therefore, the mere fact that I have responded to an email by writing an email may not actually mean that I've communicated. In fact, culturally and politically, depending on the stakeholder you're dealing with, that form of communication may be regarded as being disrespectful. And therefore, communication here is determined from the point of view of appropriateness by politics, culture, and stakeholder mapping and interests. Of course, agreement here is purely a matter of intellect. It occurs in the minds. That's why, for instance, as lawyers, we recognize that it is a meeting of minds, consensus added them. Today, courtesy of especially the MIT Harvard project on negotiation, we say that negotiation has attained the status of science. That's why when you go through a book like Getting to Yes, you see that negotiation today is governed by certain principles that if you apply them consistently, adapting them to suit particular situations, you're likely to obtain a particular outcome. But that is not the end of the story. Negotiation is at the same time an art. And that's why a man wrote a book called The Art of War. And the reason being that apart from being a science, you also need strategy and tactics in order to win. Today, predominance of evidence suggests that negotiation is actually an art, but based on science. Just like medicine today is said to be an art, but based on what? Science. Where did negotiation come from? So that we under no illusions at all, we did not invent negotiation. Today is as old as mankind. And therefore, when you go through all the holy books, you'll find evidence of negotiation as defined between man and man, between man and the Almighty. And therefore, I leave it to you. So please go through Genesis. You see evidence, Sodom and Gomorrah, all those kind of areas. Again, the Holy Quran, praying 5 times a day today did not come on a platter of gold. In fact, it was to be 50. African societies, please just attend a traditional marriage and you'll see evidence where everything is negotiated in a culturally and politically appropriate manner. And therefore, let's not be under any illusions that it is a modern development or phenomenon. It has been with us all these years. Now, sometimes, both in business and in life, politics, labor relations, which is the subject matter we've been dealing with, stakes are very high. A party feels completely enraged. Demonization may be rampant. We do not talk to terrorists. In fact, an American president will refer to some people as axis of evil. If you read a book called Bargaining with the Devil, written by a man called Professor Robert Nookins, Nookins as in M-N-O-O-K-I-N-S. He talks about the 4 global devils. And therefore, there are times when demonization is rampant. There is a desire for revenge. We want to teach these guys a lesson. Who are they? We demand justice. Strong aversion to rewarding the enemy with negotiation. Look, some people will tell you this is a battle between principle and pragmatism. Kwame Nkrumah, in his book called Conscientism, says that any compromise in the area of principle is tantamount to abandonment. And therefore, some individuals, we cannot negotiate based on principle. No, nothing like that. And therefore, you find those are times when you need to make a decision whether to negotiate or not. Will this be an opportunity? Because this is an enemy. This is a time to do a fight to a finish. That is the subject matter we have today. Permit me at this stage to pick out some moments in history, in summary manner, and then to see how some historical figures took decisions as to whether to negotiate or to fight. And at the end, who will be the judge in terms of could they have done something different? On the basis of which we'll now begin to look at whenever we are faced with those kind of situations, whether in family, whether in labor, as Okechukwu said at the very beginning, what are the things that should guide us in taking decisions that history will always remember us for? Donald Trump, although not very popular today, but he once said in his book on negotiation, too many countries, too many businesses, and too many organizations, including unions, have been destroyed by not studying history. Can you imagine? Trump himself. So let's pick some moments in history. This is very arbitrary, I must tell you, but I just picked them for emphasis. Second World War, Cuban Missile Crisis, Nelson Mandela, IBM, Fujitsu, corporate Nigeria. We just say a few things concerning them. And let us see decisions that were made as to whether to negotiate or to fight. Second World War, even though it was purely an European war, but it was called Second World War anyway. Now, the treaty, international agreement that brought the First World War to an end, called the Treaty of Versailles, was so one-sided that Germany lost territories. In fact, the current Czechoslovakia, part of Poland, were all at that time within the German conclave. The treaty actually caused Germany to sign. Europeans, generally, through popular press, all agreed that the treaty was very unfair to Germany. Hitler, as a young man, was growing. He felt so. In addition, Germany had to be paying reparation. And therefore, it is on record that Germany, through Hitler, requested that this treaty, purely territorial, be renegotiated to avert another war. Italy, I'm summarizing, said that that would be a fair thing to do. Quite a number of press reports at that time felt that was the proper thing to do. But a man called Winston Churchill, who was leading Europe by virtue of the position of England and being prime minister, never. We do not talk to people like that. Demonization. This man was evil. In any case, we will crush him. Outbreak of Second World War. Captured Poland, France, and was to deal a heavy blow to England, but for the entry of the United States. At the end of the Second World War, approximately 70 to 80 million people died. Today, the map of Europe has been redrawn several times. Question is, why was that war fought? In fact, Great Britain voted Churchill out immediately after the Second World War. September 11, 2001 attack on US. World Trade Center. Bush was infuriated, just like every civilized part of the world. More than 5,000 Americans died, including foreigners, died on that day. And therefore, Bush, President Bush, issued an ultimatum immediately to the Taliban government in Afghanistan, shut down all Al-Qaeda bases, turn over Bin Laden to us. Otherwise, US will invade Afghanistan. Taliban, it's on record, called for what? Negotiation, please, sir. The reason they called for that, they said this issue was complex. There were multiple stakeholders, which said time was up. Afghanistan was invaded. Bin Laden was never found. The war continued. Eventually, Bin Laden was found where? Pakistan. After several years, remember, 2001, several years, it was left for Trump to begin the withdrawal. Last year, withdrawal was completed by Biden. In fact, on the final days, when American troops were all amassed at the airport in Kabul, they needed to go into negotiation with Taliban. Otherwise, one single missile would have been catastrophic. Today, negotiations have opened between the same Taliban. Most European nations being held in Dubai. Billions of dollars were lost in that war. Lives were lost. In fact, in the book called The New Rules of War, the general that led the army for years in Afghanistan, General McFate, said openly he did not see how terrorism could be defeated through armed conflicts. The time period that has now been labeled as the most dangerous 2 weeks in human history, 16 to 28 October 1962. Cuban Missile Crisis that would have led to the first outbreak of nuclear war in the world. In summary, it was a situation where America woke up one day and found that there were nuclear warheads mounted in Cuba, overlooking Florida. And America said they will not have that. And that unless those things were removed, they were going to attack Cuba. Russia said if that happened, there would be immediate retaliation. For the beginning of what was called mutual assured destruction. The public had great appetite for war. There were demonstrations in the US. Kennedy must go into war. And this was a time to teach Russia a lesson. Popular press were urging him, he's a young president. In fact, the youngest American president, he was about 40 years. And people expected him that let us settle this issue, America and Russia, once and for all. But a book written by his brother many years after said that when he reflected, he knew that the cost of the war that was to start, the Second World War would have been child's play. And therefore, he opted to negotiate. At the end of it all, the missiles were removed. Yeah, but the brother to the American president, Robert Kennedy, said that all that Russia needed to encourage them to pull down those missiles was a face saver, something to save face. And that was provided by America, making a promise that their military base in Turkey would be pulled down. That was all they needed. And the world was saved. Our own Mandela, Nelson. You see, apartheid, separate homelands, was decidedly evil, no doubt about that. And therefore, the ANC waged war, moral war. In the process at that time, by official statistics, 21,000 blacks had died by 1985. Nelson Mandela and the others were in jail. In fact, by 1985, Mandela was already 71. He had served 23 years. And therefore, in his book called Long Walk to Freedom, if you look at chapter 12, he said one day he reflected on this and said, look, would there be a better approach to this? Mandela initiated negotiation. And for 5 years, they will come in the night, pick him from jail. Negotiations continued. On one occasion, a former president of Nigeria was invited and he joined the negotiation. Because at the end of all the negotiation, positions had been shared. That was why in 1990, apartheid was dismantled, Mandela was released, and he became president of South Africa. At the end, Mandela changed history. He won a Nobel Peace Prize, and the rest you know. Let's come back to our own field. What today is regarded as the biggest war that had been fought at the corporate level, giant software war between IBM and Fujitsu. These were the two biggest in that field, telecommunications, by 1987. IBM won, Fujitsu was number 2 in terms of profitability, in terms of market share. Now, IBM alleged that Fujitsu illegally copied their software. The war started. Fujitsu was enraged
for a number of reasons. But most important was that the CEO of Fujitsu at that time was actually a kamikaze pilot during the Second World War. And therefore, this was a man who had already, at one time in his life, accepted to commit suicide. And therefore, to him, honor was more important than anything. IBM hired a man called Tom Ban, an all-out combat lawyer. Litigation became a circus, costing time, reputation. For more than 24 months, matters were still at the level of procedures. It was at this time that these two companies lost market shares because the attention was on something else. One day, the lawyers met and said, look, guys, how do we deal? When will this matter end? And they all accepted that. Let us go through assisted negotiation. You know, when we hear ADR, you know, the impression you have is an alternative dispute resolution. Certainly not. ADR is actually appropriate dispute resolution. And therefore, let us go through what is appropriate. And ADR is nothing other than what is called assisted negotiation by a third-party neutral. It took only 4 months to hammer out an agreement. A deal was made. But unfortunately, at that time, they lost markets and they were never able to come back to their full potential thereafter. Corporate Nigeria. This is a very slippery ground, and therefore opinions will vary here, and understandably so. But let me begin from the one we all know clearly. 1996 or thereabout, because my background is in the pharmaceutical industry. Pfizer was involved. Series of cases in Kano over their vaccine, which, again, based on CSR, they had brought to Kano following the outbreak of meningitis. Of course, there were other organizations like Doctors Without Borders and all those ones all in Kano. Yeah, but at that time, information came that the Pfizer vaccine was causing more deaths and that there were other things associated with it. Pfizer, based on reputation, felt shortchanged, that we did not deserve, according to Pfizer. Remember what Chesakara said. We don't deserve to be treated in this manner. Look at the science backing our vaccine. Eventually, there were a series of class actions, including the state governments. Pfizer felt that this was a matter that science could resolve. But as we shall see, at the end, they were well advised, but at that time they had lost quite a lot because all the matters had to be settled, not following the original steps. We have also seen series of cases involving ASU. We will come back and talk about this briefly in terms of could these matters have been dealt with differently? We also know the case Mobile and Spy Police, how it ended. Again, could this have been dealt with differently following the principles we shall talk about? I think so, seriously. GT Bank and Innocent Motors, at the end of it, parties had to go back to what we're talking about. Could they have started and dealt with it at that stage? Again, I deliberately picked these cases because they are cases that are known by all of us, but they are cases where, with the benefit of hindsight, we will be able to see
what went wrong. Now, in order to determine whether or not to follow the route of negotiation or to fight, you have to make a decision. That was what Okechukwu was referring to. Now, remember at the very beginning, one statement that came from Chester Karas was that today we are living in a new world characterized by what is called multiple and parallel complexities. And therefore, for you to make a decision as to whether to go one way or the other, first and foremost, when a matter comes for you to give advice, you need to make a judgment call. Judgment call must be guided by the kind of things we will be saying from now on. Number one, in the new world, you must recognize that there are two domains that are operating at the same time. Now, you see, this is not the typical business school quadrant where you say A is better than B or no. These domains represent reality for decision-making in the area of whether to negotiate or to fight. If you look at the right side of your screen, that is called the order domain. You know, you see, within this area, there is order. The left side of your screen is called the unorder. Some will call it disorder. In fact, in the book I referred to, when I talked about the new rules of war, General Maffei said, look, it should be called disorder domain. These are operating at the same time. Now, the challenge for all of us here is that the new world appears to be tending towards the domain of unorder or disorder. Now, when a matter comes to you for professional advice or guidance, and in your assessment, the matter appears simple. Example, is a process matter. There's a standard operating procedure, like in an organization, somebody violates it. There is always one best answer, scientific, logical, or the matter is a bit complicated, like it's a rights issue. And therefore, here, you need expertise. Answer is knowable, but not apparent. You know, these areas are areas that are, you know, ordered. Here we say that negotiation is recommended. And therefore, an organization can be at liberty. Your client can be at liberty on a simple matter. No, this is what we want to do because this is what should have been done. That's one best answer. Yeah, but we still recommend. However, when you enter the other domain, on other domain, this other domain, here you're dealing with complex, chaotic situation. What makes a matter complex? For instance, like in labor relations, employment issues, politics. What makes a matter complex? One, more than one right answer, open-ended. Usually, there are multiple issues, multiple stakeholders, interrelated variables. Sometimes we say the variables are interacting, mutating, producing this set of variables. Here, there is a limit to logic. Ladies and gentlemen, let me put it clear here. When matters come to you and you sense these characteristics, negotiation becomes an imperative, no longer an option. Otherwise, you will sub-optimize. Also, when they degenerate to the chaotic. You know, we hear that Nigeria is a complex society. That is correct. And therefore, there's only one way out. Furthermore, I mean, look at how the general explained this. And the Chestakaras agree. That you see, when you are dealing with matters that are complex, the diagram on your right demonstrates this clearly. In fact, the way it is put is that it is like you're playing chess. All the pieces are held together by a rubber band. You know, complicated matters, simple matters, outputs proportional to input, you know, there is still a pattern, there is an order. For complex matter, when matters are complex, there is no other approach. And that is your judgment. A mathematician, Professor Edward Lawrence, in a recent paper called the butterfly effect, he later went into weather forecasting and so on, but originally he was a mathematician. He talked about the butterfly effect in order to explain the new world. He said you must recognize the complex new world, the dense linkages, what may work could defy logic, and therefore the logic that you all know, which will guide your decision making, may not operate in a complex situation. And that is why negotiation becomes an imperative in this type of situation. Now, as we begin to shut down, let me answer a question that may be on your mind. And the question is this. Uche, yes, we recognize this, but sometimes you will have to face a difficult person, somebody who is impossible. You are trying to negotiate, he refused. We've done everything we can. We have been pushed to the wall. So what do? We hear you. Yes, you're talking about negotiation, fine. Yeah, but suppose I've done my best. I've done everything. The person no agree at all. So what do I do? And that's what takes us to our concluding part. When you now have to deal with, notwithstanding that you recognize the complexity, multiple and parallel complexities, and therefore you want to follow the path of let us engage and deal with this matter in a way that at the end, we will all optimize. Yeah, it's a difficult stakeholder. What do? 3 options that are open to you. 3 options in this type of situation. 1, that is the subject of our discussion. Fight. I mean, the guy no agree. Let us, return fire for fire. 2, just give up. And therefore, the 2 options, fight or flight. Ladies and gentlemen, we do not recommend any of these, and history will never support these 2. Because fighting in this type of situation will only escalate stress, accelerate emotional. People will go from emotional high gears, gear 1, 2, 3, 4, high gears. In fact, the worst is that irrationality or outburst may occur in the process. More so in a corporate world, it is not recommended at all. The second, to take flight always, is not even different from the first, because escapism is no solution. And therefore, there must be something better. That was why this topic was brought to me. What else can you do in the circumstance? So, ladies and gentlemen, here I want to rely on all the authorities in this regard. Institute of Negotiation, the MIT Harvard Program on Negotiation, I mentioned this earlier today, being led by Professor Lukings, We want to also look at Kremlin School of Negotiation. All of them are in agreement on this, that in dealing with these impossible situations or impossible people, difficult, in fact, sometimes I would say devilish people. You know, the world is made up of both saints and sinners, but there may be more sinners than saints. And therefore, when you're dealing with this bad situation, there is an agreement among all various schools of negotiation that this may be your best approach. And they're all coming from the Institute of Negotiation. One, you must deal with the issue of emotion. Two, you must, again, judgment, determine the type you are dealing with. They are not all the same. Three, there is a method to deal with each of the types. And then one size will not fit all. You explore options. You see, usually when we say negotiation has failed, the failure is at this point that either you did not identify the type or that your method is not the appropriate one for dealing with those kind of people. That was why we saw that Second World War. So quickly, let me just close this by looking at this briefly. You see, starting point, especially for us as professionals, we must be able to help our clients manage emotional issues. You know, sometimes we talk about emotional intelligence. However, what is important is actually emotional agility, the ability to deploy emotion appropriately. You know, it is not just being calm, even in the face of danger, but to deploy emotion as appropriate. That is emotional agility. Yeah, but for you to deal with those difficult, impossible, emotion must be under control. Composure. He who angers you, careful about it. Avoid impulse, volatility, rage. Do not counter-strike. The individual will look for a bigger weapon. Remember, we're just dealing with this in a summary manner. The next thing you must do whenever you're dealing with, you know, impossible people is that through your judgment, you must determine what is the type we are dealing with here. And this is what you must help your client to determine. There are situations where the individuals on the other side, we say they are situationally difficult. There are times when there will be strategically difficult people, and there are those who are naturally. So, ladies and gentlemen, there are different methods for dealing with all these kinds of situations and people. How do I know people who are situationally difficult? This is a judgment call. First and foremost, the situation and the circumstance will control them, certainly. They normally will overreact. They'll say they have short fuse. These people are tactless. They deploy no strategy, no tactics. And I've given you some examples. And there is one particular method of dealing with this kind of situation. Quite frankly, the last negotiation between ASU and federal government fell directly within this. Many of you know the tennis player, McEnroe, Winston Churchill, and then OBJ. And therefore, once you are able to master this, you will do well in dealings, even though they are difficult people. There are those who are strategically difficult. My little friends, permit me to say that these are the people you are likely to encounter most. in your professional life, more so on behalf of your clients. How do you know this? Where I come from, there is a saying that you can only wake up a man who is truly asleep. But a man who is pretending to be sleeping, that summarizes this. Unions, management, you know, all those procurement officers, these are professionals in their own rights. They are going to deploy difficulty as a strategy. They will be competitive. Some will say they will even be combative, because they believe that being difficult delivers results. So nothing you say will appease them. This will be the most tactical, and there is only a particular method of dealing with this kind of people. Whenever you encounter them, remember, they will be difficult. And finally, there are those who are naturally difficult. You are not likely to meet many of these. You know, sometimes you hear, oh, man is a naturally, no. He is probably strategically difficult. You see, those who are naturally difficult, this is a personality disorder. For instance, whenever they appear in history, the world will recognize them. They tend toward genocide. In fact, they are called genocidal madmen. And you could see them, not too many in history. But sometimes people will confuse those who are strategically difficult with being naturally difficult. That is a misconception or misclassification. Now, how do you deal with these kinds of people? You know, for situationally difficult people, history has taught us that, you know, you can easily manage those situations by what? De-escalate. You de-escalate. And therefore, this was the main problem during the ASU negotiation. Honestly, rather than de-escalate, they were escalating. And therefore, there was no way that matter would have been settled. De-escalation. Again, we don't have enough time to go through again what it was due to de-escalate. For strategically difficult people, ladies and gentlemen, you must determine the tactics and deploy a counter. You win against these people, or you are able to reach a compromise when you have deployed a counter to their tactics. That is the only way out. Naturally difficult people, here, history has taught us you need a third-party intervention. Because that was what Kennedy did. And again, in labor relations, that is where, for instance, the Minister of Labor will now begin to tell you about what even the ILO recognizes as tripartite plus intervention. As we conclude, ladies and gentlemen, I will mention that even while you have been able to determine the kind of person, difficult persons you're dealing with, one size will not fit all. Therefore, there are a lot of options. And all these options are accommodated within negotiation. But let us begin from the negative. There is one option that must be avoided in dealing with this type of situation, impossible people. And that option is the option of issuing ultimatum. History has taught us that this will never help situations. Ultimatum without option will lead to impasse. Avoid this. What saved the world from what could have been the Third World War was that a face-saving opportunity was given to Russia, no matter how small. So create menu to provide face savers. I think that would help, even in the case of dealing with Niger. One option that will always work. Remember, I'm summarizing. I've taken one that will never work, so don't go there. One option that will always work, in addition to others, whenever you are able to disarm. It is never easy. You can't go to a man who is armed and say, now surrender your weapon. Never easy. But you disarm through a series of actions. And I'll just give you one example. The reason being that that is the normal approach of Coca-Cola. They said, look, what do? We yield. Yield does not mean surrender. And the drawing here is plain things. Moving back a few inches allows you to remain whole so that you may perform next maneuvers. You can't afford a puncture. If you read the book called The History of Coca-Cola, you see how this is put into effect. Yield does not mean surrender. And therefore, whenever you are dealing with this kind of people, this is the time where you know where you yield ground, because that enables you to be strong in other areas. Conclusion. Especially in employment relations, the purpose of tactics in whatever you do is victory and not self-destruction. You need options to ensure success and options in the event of failure. The only institution I know in the world that offers you these options happen to be negotiation, not even litigation. One problem I saw with the ASU case was that there was no exit strategy. And therefore, they were left stranded, completely stranded. I end officially summarizing the lessons from it. If you read the book where he documented historical evidence, a man called Gavin Kennedy, it has this title, Everything is Negotiable. And therefore, when you hear that negotiation broke down, it failed. No, it didn't fail. It was just incompetence of the people who handled it, either because of wrong strategy, either because they did not follow the approach you have mentioned. Remember, it is not easy, certainly, but that negotiation cannot fail. The reason being that by definition and by the ingredient, it has every reason to succeed. So, ladies and gentlemen, I want to thank all of you for your attention, and then to say that we can take any issues you may wish to raise at this point. So thank you very much.
Thanks a lot, Uche. Good to see you again. It's always a delight to listen to you. And today, once again, you've taken a very technical topic and you've made it extremely interesting to listen to. Thank you very much for today's delivery. I would invite Kunle Ajabwe, first of all, to do something that I think we should have done right at the beginning, but we failed to do. And I consider it important that we still do it because it will give some perspective to the person whom we've listened to. So Kunle, please, I'll ask that you read Dr. Atto's citation. Thank you.
Okay, good afternoon, everybody, and thank you for this opportunity. So my duty is to just take us through the profile of Dr. Uche Ato. He's a veteran of 4 mergers, and he had his early tutelage at the Industrial Court in Kenya and the Court of Co-Determination Mainz in Germany, and the Commission on Conciliation and Arbitration in South Africa, under the auspices of the International Labour Organization, ILO, as part of career exposure in the area of judicial globalization. In 2005, he was appointed into the Industrial Arbitration Panel in Nigeria, where for 8 years he presided over tribunals in Lagos. Prior to his appointment, Uche worked for over a decade in GlaxoSmithKline PLC, where as Human Resource Director and Company Secretary, he covered West and Central Africa region. He played a pivotal role in the company's successful change and turnaround programs. In particular, he led the legal and HR integration of SmithKline Beecham with Sterling Health and SmithKline Beecham with Glasgow Wellcome, consequent upon the respective mergers in Nigeria and in other countries in the region. Before joining GlaxoSmithKline, Uche was Director, Industrial Relations and Legal Services of the Nigeria Employers Consultative Assembly, NECA, where in about a decade and a half, he gained significant international HR experience through secondment and fellowship by the international labor organizations to organizations in the USA, UK, Ireland, Germany, Brazil, Norway, Kenya, and Ghana, respectively. During this time, Uche was also a board member of the National Salaries and Wages Commission and National Labour Advisory Council, the 2 statutory policy organs in the area of labor and social policy in Nigeria. Uche is a fellow of the International Institute for Labor Studies in Geneva of the ILO. Currently, he is a senior fellow and head of the Department of Organizational Behavior and Human Resource Management at the Lagos Business School. He brings to the classroom, and I believe we've all seen elements of that, over 4 decades of local and international experience in human resource management, negotiation, and arbitration. He also teaches employment law and strategic human resource management. His research area is in the area of peace and conflict resolution, and he speaks regularly at conferences on this topic. He has also written a number of cases on negotiation, human resource practices, and law, which are used for classroom discussions. Ladies and gentlemen, dear colleagues, that is the profile of Dr. Uche Ato, and we thank him immensely for sharing some insights from his professional experience. Thank you so much.
Thank you very much, Kunle. And I'm sure that all attendees now understand why we asked Uche to take on today's topic. Many years of practical experience in negotiations, spanning across the private, public sector, and even the academia. So thank you very much. Before we go to the question and answer segment, I'll invite the panelists that have been, or the facilitators that have participated today, to give their comments or any perspectives that they have on today's session. First, I will invite, I don't know whether Folabi Kuti is still here, but I can see Mr. Inam Wilson, Senior Advocate of Nigeria, for his comments. Inam.
Good afternoon, everyone. Can everyone hear me?
Yeah, Inam, we can hear you.
Okay, fantastic. I'd like to thank especially Dr.
I'm not sure we can see your face, though. I'm not sure we can see
I am also looking for my face.
Okay, we can see you.
There you go.
Good.
It's
always good to see you, Inam. So, yes.
I know, right?
Yes.
So that was a brilliant presentation from Dr. Uche Ato. Exceptional, very rich, very resourceful. And I like the content and the approach to it. I know we are employment lawyers, so he took us around the world and still brought us back to employment, industrial relations, and all of that. And I think the takeaway from his presentation are the principles. And it's important that we bear these principles in mind, because for those of us who do dispute resolution, and which includes what he has appropriately described as appropriate dispute resolutions, we get to negotiate on a daily basis in our professional life. For the number of decades I've practiced, I've been involved at many levels, and those principles that he has brought to bear, I have found them play out. And you would find that it's not just in industrial relations, but even in commercial and business relationships, you need to negotiate. So this is a very, very important topic. I can even share an experience recently, or maybe one or two experiences. So there was this tech company, very big in West Africa, and the two founding founders went into very serious disputes. It went beyond commercial issues. It devolved into ego and personality clashes. You know, it became a Nigeria-Kenya fight at one point. But after both parties locked each other up in litigation, there were litigations in Nigeria and outside Nigeria, litigations in federal high courts, industrial courts, state high courts. There were litigation involving the board members, litigation involving the company and staff. It was a real mess. And when everybody got into an impasse, somebody said, can we discuss? Can we negotiate? And we spent 1 week in Abuja in negotiation. And it was amazing that all the big guns, they were in one room. And within a period of a few days, we were able to come to some kind of an agreement. And it was a win-win scenario for everyone. At the end of the day, litigations were withdrawn and discontinued. And they've all gone their separate ways, but at least if they meet in future, they will shake hands and say, it was nice doing business with you. I think that is what Dr. Atto has brought from his presentation. And for some of you who have to deal with the unions, they always say the unions are difficult to deal with. Negotiating with them is almost like negotiating with Russia and all of that. But you find that sometimes you get into dispute with the unions, and you go into litigation, you go to the Ministry of Labor, you go to all those places. At the end of the day, it's negotiation that eventually brings the dispute into resolution. So thank you again, Dr. Atto. Very good presentation. I look forward to the question and answer sessions. Thank you, Tobina.
Thank you, Leonard, Senior Advocate of Nigeria, and I'm Wilson. Thank you. I'll now invite, I don't think Folabi Kuti is still here. Folabi, are you there? Okay, I think he's dropped off. Mr. Umemo, okay, your comments.
Yes, I join the Senior Advocate in thanking Dr. Atto for a well-resourced, simply presented paper. And for those of us who are into dispute resolution for a long time, I think I picked up quite a lot of things. Essentially, we have this attitude that when there is a dispute, our usual approach is that even if it is a matter we want to settle, we want to show the other man what we have in our arsenal. There's always this disposition among practitioners to first show the man I can fight, that if you don't show him you can fight, he might take it for granted when you want to negotiate. So I've learned from the way Dr. broke it down, that by understanding the person's situation, trying to, maybe I can use the word, get into his head, you can actually take off from negotiation, try to find out how you can disarm the person, find out what it is, approach that can make the person be more amenable to settlements. I think it is something that is fantastic, and it is something that practitioners all over Nigeria in particular need to work more on. Experience has shown that we don't do it enough in Nigeria. Experience has shown that there are matters that ought not to linger in court for years, that eventually spend 20 years, for example. I've known matters that went all the way to Supreme Court before they came back to the High Court again, and the judge at the High Court was able to put them in a round table, and they were able to resolve the matter. So if we do this a lot, it will benefit our clients more, because there are matters where essentially why people are fighting, why they come to lawyers, was because people are angry about one thing or the other, people are dissatisfied about one thing or the other. People could simply be angry because they were not treated in a manner they would have loved to be treated, or spoken to in a manner they would have loved to be spoken to. If this person, somebody with the kind of experience that is being put on display today, that we are being asked to imbibe, will be able to see what are the situations, what are the issues that actually get this person to be this offended, and be able to talk around those issues and resolve the matter without escalating it. It will save resources, it will save costs, it will also help to decongest our costs, which are overly burdened. Thank you very much, Doctor, and I look forward to contributing more if there are more questions that need my intervention.
Thank you very much, okay. I think I like that angle of decongesting the court dockets. And I think that Dr. Atot took it very simply, broke it down for everybody. At the end of the day, what you want to achieve is a resolution. And I think that all the modern sort of pre-action protocols and modern rules of court across the world is actually geared now towards speedy resolutions through negotiations where possible, so that, again, we don't have heavy court dockets and then delay in justice delivery. Thank you very much, okay. Now to questions. Dr. Ato, the questions are likely for you. The first person is asking for soft copy of the presentation. I guarantee you that you will have it at the end of the training series. That is our normal protocol. And the second question is, he says, will it be proper in a situation like that to advise your client for ADR? Unfortunately, I don't think that we can take this from Salisu. Salisu, Bature Salisu, if you're still here, you might want to rephrase that question because it's not very clear. Then we have one from Tara Isida. Tara wants to know what course will the facilitator recommend for those who want to train as negotiators. So, Uche, you've inspired someone today. The attendee wants to become a negotiator and wants to know whether there's a course of study that would help them get into this space.
All right, thank you very much, Tara. For years, the Nigerian Law School did not really bother about negotiation. But as I understand it today, that the law school offers sessions on ADR, which sometimes people refer to as alternative dispute resolution. Yeah, but it's better to call it appropriate dispute resolution. And therefore, the law school has introduced it, not really at comprehensive level, but to draw attention of lawyers to, again, another means for supporting your clients, especially when the matters fall within what we described as, very complex, not straightforward, and therefore, these are kind of matters that courts are not really equipped to handle. For instance, like the IBM Fujitsu, that those variables are not really for courts. Now, the other thing is that today, we find that there are quite a number of bodies trained, not just lawyers, but people who are interested in negotiation. And therefore, when you Google for those kind of bodies, conflict resolution bodies, there are Institute for Arbitrators and Negotiators. Some are in Abuja, some are in Lagos. And once you Google, you will get all those information. And then you follow a particular course of study. Those studies normally will capture the principles of negotiation, the strategies and tactics, mediation techniques, and so on. And at the end, you are certified. There is a certificate where you can use to practice. There are quite a number of our colleagues today who I know are lawyers, but they are practicing in that area. And again, you know that in Lagos in particular, there is the multi-door court house where judges transfer matters to ADR. And therefore, there are those who practice in that area. And therefore, for Tara, please just Google, you get all the information. Just Google arbitration courses in Nigeria, arbitration bodies, and all those, and it will guide you appropriately. Thank you.
Thank you very much, Doctor. The next question is from Jeffrey Ebo, and I'm sure it's the same Jeffrey Ebo who is the author, our friend. Jeffrey wants to know, he says, how do you deal with opposing parties who are strategically difficult in a conflict resolution? For instance, they are corporate entities and they feel that if the matter is resolved in the course of negotiations and the individual on the other side appears to carry the day in the resolution, it might instigate others in the same conflict situation with the said corporate entity to initiate actions against them.
Okay. Okay, I get the point our colleague is making by asking that question. And remember, for those who are strategically difficult, and I said that as professionals, this is where your professionalism will be taxed, because most of the cases you are going to be dealing with will involve the type of scenario our colleague just painted. People who will be difficult just for the sake of being difficult. The reason is that they want to drive a particular concession from you. Therefore, these are the kind of people that would be very, very tactical. And therefore, the particular tactics he has mentioned is that, how do I, in a situation like this, ensure that even if I go ahead to do a settlement with these, it will not immediately encourage others to begin to bring similar actions, so that at the end I will appear to have been weak. In the sense that because they are waiting to see the outcome of this particular, and therefore they will ride on the back of that. There are different approaches. For instance, the Institute of Negotiation says clearly that, you see, this is a matter, in fact, the way it is put is that this is a matter that requires multi-party, so that you're not going to even do only one negotiation. All the interested parties. And that's why that even in labor, for instance, one of the things we encourage in this situation where employment can be triangular, part of the things that we encourage is that when you now have issues in the organization, you will ensure that in the negotiation, the discussions that you are going to hold concerning that matter, ensure that all the parties, both the ones directly involved and those ones that are potentially or tangentially connected, are brought to the table. And that was what, again, the Minister of Labor called tripartism plus, because the law even allows it. The ILO encourages it. So in a situation like our colleague is mentioning, one approach, of course, there are several approaches, is that ensure that whatever discussion you are holding will involve all those who are involved in similar situation, so that you are doing it once and for all. At the end, you come up with what we normally will call a memorandum of understanding. When, I'm sorry, I need to call names of organizations. When a particular company in Ogba that makes lager had a problem similar to what our colleague mentioned, what we recommended is that everybody who was involved, not only in that particular case, but all the other people must be brought into the discussion so that the settlement is done once and for all. And at the end, there is a memorandum of understanding that everybody is a signatory to. That was the approach. Thank you.
Thank you very much, Doc. I think that's a comprehensive answer. That's actually a follow-up, but I think it's been covered by your response. Thank you. Now we have Marcos Eyahoma. Says the attitude of the people of any society will determine whether or not negotiations will work. Nigerians are usually recalcitrant in dispute resolution. Do you think negotiation will work in a country like Nigeria? Which I mean, I'm sure you can speak to this from many practical experiences, so that's right.
Yeah. All right, thank you very much. From experience and then also research, we have seen that culture directly affects negotiation. And therefore, the way I will negotiate with an American, the way negotiation will be held with a Russian will be different. And therefore, I can understand the point of our colleague in characterizing Nigerians in that manner. All he is saying is that we must take into account the culture of the Nigerian whenever we're talking about negotiation. For instance, we talk about emotion, highly an emotional society, and therefore you need to take that into account during negotiation. We also talk about the need for respect, communication patterns. During a particular merger, I was involved in 4 mergers. During a particular merger negotiation here in Nigeria, of course, a multinational, but we had to do a similar negotiation in Nigeria. We discovered that one of the things that actually enhanced the negotiation was our ability to communicate in a manner that was very respectful of the chairman of Sterling Health. You see, that went a long way. Here was a man that would have been would fit his characterization, recalcitrant. But you see, background information, background studies had given us this profile. That here was a man that, except you acted in a particular manner, that you were likely to meet the characterization our colleague gave. And therefore, based on the culture, we knew how that matter should be addressed. And therefore, my answer to his question is that I totally agree that not just Nigeria, when you're dealing with, for instance, a man from East Africa, we recognize their approach to negotiation. From the point of view of being direct is considered very offensive. Therefore, they prefer indirect communication. So that when you're dealing with a Nigerian, you need to do some background check. And therefore, even if you're not getting excitement from the other party, but at least you reduce hostility, that will go a long way. So I agree, but it is for you to dial into the cultural requirements, because that will enhance your negotiation. But it is not that any culture in the world we reject negotiation. There is none. It is for you to see what will be culturally acceptable and to dial into it.
Thank you, Doc. I just thinking about our question, I thought about the fact that if it's a cultural thing, then it's a two-way thing. So the two parties in dispute, someone, of course, has to initiate the negotiation. So if the culture is not to negotiate at all, then you don't even start talking. But if one party starts the negotiation and indeed it applies the technique of disarming the other party, as you say, in fact, that approach might even aim to disarm. But I'm sure that all of us in the course of our practice have found occasion to negotiate. And there are times that it has really, really worked. So I think we should always continue to try. The next question is from Ayotunde Ogundare. Ayotunde has interestingly decided to ask a live question. I mean, I'm sure, Doc, this is something you would ordinarily charge money for, but he's privileged to have you on screen, so he wants to take advantage of that. And hopefully everybody learns from his question. So he says, my client took a loan from a finance house for a term. Before the term expired, the client asked for a loan extension and was granted. At the end of the renewed term, the client could not pay and asked for another extension but was denied. The client got the money and paid off the loan. The finance house asked for a restructuring fee and my client contested that it was not in the loan agreement. Neither was it communicated when the extension was granted. The finance house retracted their demand for restructuring fee and in its place asked for default fee, which was part of the loan agreement for the period of extension. My client said there was no default because he asked for extension before the tenure expired and was granted. There was a meeting where this was discussed and the finance house rep said he would communicate a waiver of the default fee in the extension period or otherwise after the meeting. The meeting was held 3 weeks ago. The finance house, just a second. The finance house has since refused to respond to mails, calls, SMS. What would you advise? My client still has security with the finance house and has paid off the loan, but we can't reach or communicate the loan house again. My client is located in the north, finance house is in Lagos, and the client does not want to consider going to Lagos in person. Interesting and tricky, but I don't know how you want to deal with that.
Well, it's like I said, it's a complex matter. Well, let's hear Okay's here. Let us hear Okay's views. Okay was listening just like I did. But it's a complex matter. You know?
Okay, that's
okay. If I understand what he's saying, when the extension fell for the second time, his client eventually found a way to pay off the debt.
That's what he said, yes.
Yeah, so I think essentially, if I were him at this level of negotiation, I don't know whether they have tried apart from writing letters, which is something I've done personally. You are dealing with an organization, you send in letters, the other persons, maybe it takes some time, it's put down to somebody who takes a standard form response. Bank does it all the time and also send you a response. That it might be necessary to look at the letters we exchange or the emails we exchanging, pick up a phone number there, put a call across to somebody and say, I'm counsel who is involved in this matter. I've been trying to reach some kind of agreement. Look at the position. This amount has been paid. Why are we unable to close it? If you put that personal touch to that negotiation, it might be able to work out just fine. And where that fails, you also have to consider what are the other options. If you have to go to court, for example, to compel them to release the mortgage documents that they are holding over, the time and resources it will take, and the time it will take you to come down from the north and engage somebody physically, if you compare the pros and cons, you might say that pursuing this negotiation further might still be more fruitful if you can engage. If you are unable to get through the telephone, try to put a personal approach to it. Come and sit on a table with them and discuss all the issues. If you're able to resolve it despite the inconveniences of coming down from the north, it would have been better than the other option of going on a lengthy and protracted litigation.
Thank you, okay.
Yeah, thank you. Yeah.
Go ahead.
I will only add here to Ayotunde, you are already long way into the negotiation, because from the very beginning of your story up to this point, you have shown clear evidence of negotiated outcomes in terms of how you were able to get all those extensions and the various closures. So you're actually at the tail end where you should follow the same approach. Yeah, because you see, any other thing that you do at this stage, other than what you have started, will defeat the entire purpose. So that, yes, what Oge said is the correct thing, but just look at what you have done or what has transpired from the very beginning. You know, getting all those extensions and then now being able to, you know, it's just a closure. This is not a time to now go back and then deploy any other means. Remember that even though we simplified everything we talked about negotiation, it is not that it is easy, certainly not. It is not that once you meet the opponent and then there's an agreement. I mean, there will be a lot of tactical displays. There will be a lot of inconveniences. For instance, I mean, you go, there is somebody you're supposed to see, the individual does not see you, you come back. All those are personal issues. Yeah, but your objective is to ensure that you close. So do not dwell on those personal issues and then lose out on what you had already gained. So please continue in this. Don't have the impression from my presentation that negotiation is so easy, that once you begin, it is done. I've negotiated, excellent. It is equally tough. The only thing is that the outcome of negotiation is always superior to any other outcome. That is why we're recommending it. So no matter the sacrifice you make during the negotiation, no matter the insult you receive in the process, I mean, you need to know what we go through when we negotiate with some clients, or let us even call them trade unions. Personal insults you receive. I mean, directly. I mean, there was one I was involved in recently. He said, Uche, how much did they pay you? This is why you're talking like this. Yeah, but what do? You go on until you get the outcome. And the same individual will come to you, Organo Vex, so you know, now just they do our work. Or you let it be. So thank you.
Yeah, so thank you very much, Uche. Thank you very much, okay. I actually feel a bit of sympathy for Ayotunde in the matter. It's not clear from his question whether the bank actually gave a discharge to his client, but the fact that they are detaining the security suggests that they indeed have not. It's also not clear what level of recording took place between the first level of negotiations and the second level of negotiations. So when they considered that there was no extension fee, and then where they said they were not going to apply the default fee after all, I think it might also help to look at the level of authority of the person who made that concession, and then try to find whether the problem is from his superiors, and just try to find a way to walk around that organization and make sure that it gets the attention of the appropriate person who should attend to it. So also identifying the exact person you're negotiating with and being sure that the person has authority to deal with the matter, I think could help you in this instance, my personal view. So last question. Thank you, sir, for the brilliant presentation. Dealing with difficult parties can be draining and time consuming, especially with people who you referred to as having personality disorder. how do you convince these people to yield to appropriate dispute resolution?
All right, thank you very much. I'm so glad you also picked out that part of the presentation. That, again, because the Almighty Father has created us differently. You, from time to time, may come across people whose problem is just a personality issue. And it's a judgment call. You will know this is a personality issue. Now, the recommendation, and that's again what experience has taught us, the recommendation is that in those type of situations, the most appropriate approach, an approach that can deliver result for you, is that there is need for a third-party intervention. And the way it is normally put is that no matter how bad an individual is, there must be somebody that person is accountable to. So the job you need to do is to try to discover that kind of person who should be able to call that individual to order. Yeah, because remember, it's a personality disorder. And such a person can lead you to, commit something that ordinarily, as an individual, you will not have committed to. So that's where you have to be very careful, because you can commit your organization to a course of action that the organization will regret. So this is where you may need a third-party intervention. And pardon some examples I will give here. We have seen situations where at that stage, people have gone to find out who probably was the pastor of, let's assume the individual goes to a particular church, the pastor. We have seen situations where people had to go through the spouse of that individual so that you are able to get some closure, so that you do not go and commit an organization to a course of action based on the personality trait of a particular person, because it's a disorder. So there's no other way you can. That's the way God has created him anyway. In any case, he is the person representing a particular organization or institution. The individual, let's assume for the purpose of argument, may be the minister of the Federal Republic. And it is not your call to remove that individual. And at the time he's still the minister, yeah, the decision he makes in that regard will be the official decision that may harm your organization. So that will be the approach in dealing with those kind of people. Thank you.
Thanks a lot. Thanks, Doc. Chidebere Okorafor has asked he wants to know what is not right or good about negotiations, or does he take it that negotiations is so perfect that nothing is wrong with it?
All right, Chidi, thank you so much, because you are actually drawing attention to the fact that negotiation as an institution could also be abused. And therefore, we should not over-glorify it. Totally agree with you that no institution in the world is perfect. In fact, we've talked about democracy, not perfect. Yeah, but the argument here is that imperfect as it is still superior to other institutions in terms of outcome. Because if you look at the alternatives to it, they produce outcomes that have proved to be inferior. Not even litigation. So, but negotiation, imperfect as it is, still will produce the most superior of every other institution that mankind has been able to develop for dealing with conflict situations. Remember, we're talking about conflicts, inevitable, and we define situations where we say that there are vast areas of legitimate conflict. It is legitimate. And therefore, this is a game of life. You need strategy, you need tactics to play it, negotiation. So, not perfect. Yeah, but there is no other institution that can produce an outcome so far that appears to be superior to it. That's why we're talking about it. We do not know what the future holds, but so far. And that's why, for instance, as our colleague mentioned, that the approach to conflict resolution today, all over the world, appear to be tending in that direction. That's why you begin to see all this ADR. That's why when you read most commercial agreements, you'll find there is an arbitration clause as the first step toward resolving conflict. And this is the preferred approach. We know that there will be other approaches, but please let us deal with this, imperfect as it is. Of course, it can be abused, I totally agree, especially in a situation of power imbalance. We recognize all those. But so far, it is the one that gives the most in terms of outcome. It produces outcome that appears to be superior to every other outcome. Okay, I don't know whether you have any comment on this as well.
And I'm most of the senior advocate of Nigeria is still here. If you want to
yes, sorry. It's because I'm not seeing his face often. Leonard Silk, I apologize. My respects, Leonard Silk.
Okay. Absence makes supposed to make your heart go fonder, but it's fine. Okay, so that last question was rather interesting. The reality of life is there's nothing that is perfect. There's no system that is perfect. And I have been involved in negotiations that didn't end well, and the parties have not been able to resolve the issues in spite of everything. And I've been involved in some that have ended well, and the issues were resolved. So the reality of life is that you should have options. When you negotiate, have a plan B, or negotiation could be your plan A, and going to court plan B, or going to court could be your plan A, and negotiation your plan B, depending on the circumstances and situation that you find yourself. But don't put all your eggs in one basket. And the truth of the matter is that you'd never know which of them will yield the result. But there's something I wanted to say based on some of the questions that came out. One of them is time. There are some elements that need to be factored into this conversation. Time. How much time do you have? Some people want to resolve the dispute within a short time frame. And sometimes it's impossible to do that. Sometimes you need a lot of time for either passion to grow cold, or for reality to set in, for the parties to understand that perhaps fighting doesn't yield any results, so we should talk. So time is important. Time will determine the best approach. That's number one. Then number two, resources. How much resources do you have? Sometimes negotiation can be expensive, and sometimes it can be cheap. Sometimes litigation can be expensive, and sometimes it can be cheap. So it depends on the situation that you find yourself. How much resources do you have at the end of the day? I think the one that, for me, is the worst case scenario is when you've spent all all the time that you think you have, you spent all the resources that you think you have, and the matter is still not resolved. You've gone to courts, the matter is still dragging in court. You've tried negotiation, it has not yielded any result. I have so many cases that, for instance, a case that we did in the High Court in Lagos, the matter was referred to the multi-door house. We tried negotiation. We were in negotiation for a number of years. It didn't yield any result. We are back in court. We've left the High Court. We're in the Court of Appeal. God knows the Supreme Court is there, staring at us, watching us, waiting for us to come. And that is one example, one good example of a matter that could have been resolved, because it is a lease. If the dispute involves a lease, for instance, for God's sake, at the end of the day, a lease is a lease, so it's tied to a time frame. The lessee cannot become the owner of the lease at the end of the lease period. So which means time is of essence in that kind of dispute. So if you're involved in that kind of dispute and you're the owner of the property, you should be weighing your options to say, how long do I want to fight? How long do I want to litigate? Considering the period of the lease. You don't want to have a lease of 5 years and do litigation for 10 years. It means that you've given the lessee, the lessor, the tenant 5 extra years. You don't want to do that. So that's the other thing. There's another one I'm involved in also, you know, and we are in court. And I know that the reason why we're in court is because of emotions. It's not law. It's not the facts. It's just emotions between the parties. And for a matter like that, I know that it will require, as Dr. Atto has recommended, it will require getting the intervention of a trusted third party to come in and resolve this matter for them. Then another thing I think I should point out is that when you're instructed by a client, the client doesn't instruct you as counsel to go and negotiate. The client instructs you most of the time to go and fight. And so at what point do you bring in negotiation? If the matter goes to the Lagos High Court, for instance, where ADRO is part of the litigation process. So it means that your attention will be drawn to it and the client will understand that, okay, there's need to have a conversation about ADRO. But if it is not, then do you as a lawyer raise the issue with your client to say, this is a matter that we think we can negotiate? For some clients, they may see that as a sellout and they'll say, no, that's not why I engaged you. And therefore they walk away from you. So as a lawyer, you have to make that call also. So that's the thing there. Those are a few points I thought I should just to make. Thank you.
Thank you very much.
Thank you very much, Lana Sekinam. Okay, you have to button at a future point because I think Kinam has exhausted that brief. So I thank Doctor for the impactful presentation. I have a certificate in ADR. Please, I want to know how I would develop in this area. Thanks.
All right, thank you very much. I'm glad that you already received the certification in this area. The next thing you must do is to now begin to grow your competence in this area through personal development. How do you do this? On your own, please try to visit the multi-door courthouses so that you participate in what is being done. Not that you are one of the parties, but you learn practically from what is going on in those places. And then that enables you to grow in the skill. I have also gone through those certifications, and I find that it is the normal training you get even at the law school. Yeah, but that does not give you the practical skills. Practical skills you need to develop on your own through practice. And therefore, if you're in Lagos here, you have a great opportunity to be present in those places. And then from there, you need to attach yourself to one of those centers. Again, when you go to those court houses, you will be aware of those centers. There was one at one time being headed by Bumi Oni, who used to be the MD of Cadbury. You can register there, and then because of your certificates, there are many, not just one, so that from there you begin to grow. Once you register, you follow them when they are handling matters and so on. That is when you improve your skills in those areas. But know that from now on, your growth will be mainly through personal development. The acquisition of the certification is not the end of the journey. It is the beginning for you in this area. And as you learn, your reputation will be growing so that people can independently invite you. But that will take a while. Thank you.
Thank you very much, Doc. Somebody's asking about not having gotten their materials from previous training sessions. I'll just say the materials are sent to everyone on the mailing list, but you can make an inquiry directly through the secretary of your branch or through any member of the ICLE that you can find. So the next question is, being situationally difficult and strategically difficult, please, what is the dividing line? This is because there are some situations where a person could be difficult just to win some points. Would that amount to being situationally or strategically difficult?
No.
Did you get that, sir?
Yes, I got that. Are you here? Can you hear me?
We can hear you loud and clear.
Great, great. First and foremost, remember that those categorizations are not watertight. Sometimes it's a matter of preponderance. Somebody is more of this than that. But generally, the categorizations will help you in planning your approach. And therefore, you still see elements, especially between the first two you mentioned. Now, and that's why we put some examples to guide you, especially in those situational. For the situationally difficult people, you find that ordinarily, the individual would have probably been acting differently, but for circumstances, he gets impatient because of particular circumstances. For instance, this is an election year. Things are moving rapidly. There's need to end certain things. And therefore, there is time pressure on the Minister of Labor. It's purely circumstantial. And therefore, in that kind of situation, whoever is dealing with him, you need to be very, very careful. And the individual may become unduly impatient, become hostile. Remember, some circumstances are forcing those type of behavior on the individual. So you recognize that when you de-escalate and say, okay, these are the situations. In which case, how do we manage? Usually, the hallmark of those situationally difficult people is that you are not likely to find clear thought out strategy and tactics. Most unlikely. They will rather overreact, not based on any strategy, Those who have dealt with OBJ, they will confirm this to you. But when you are able to de-escalate, what does that mean? It means that you recognize when certain things can be, and you get a favorable hearing. I mean, there are times that it becomes amenable to certain things. We don't have all the time, and the audience is quite wide, and therefore there are some examples that will not be appropriate. But certainly, people who recognize this of OBJ were able to always de-escalate. And in so doing, they got their way. Because that was his standard method of operating. And therefore, those people, in discussions with him, in communication, which we call negotiation, they were able to score high because they understood that of him. And so also, like we mentioned, we thought ASU could have done much better than they did if they took certain things into account. Rather than de-escalate, they kept escalating at that period. And that's why they ended almost in self-destruction. Because that was going to happen anyway. And that's why 2 additional unions have been created in that sector, almost destroying us. It was going to happen. It was bound to happen. Because rather than de-escalate, they were escalating at that period. Yet they had no exit plan. They had none.
Thank you. Thank you very much, Dr. Uche Ato. I mean, I think that this has been a very, very brilliant lecture today. I think the question and answer session was also very illuminating. I thank you very much for accepting to speak to us today and for a well-presented and very brilliant lecture. Thank you very much. We're very grateful. We know how technical this is, but we know that you do this every day. So thank you for coming. And I would like to also thank all the other facilitators and to make the point that colleagues like Dr. Uche Ato do what they do for us at absolutely no cost to us, the attendees, or to the MBA itself, no honorarium, nothing. So we owe a debt of gratitude to them, especially for giving of their time, knowledge, and resources in the advancement of colleagues and indeed the profession. It is a truly great Nigerian example and a truly great Nigerian story that people actually seek to give back. Indeed, that the MBA itself has discovered a knowledge gap, and that a community of experts have come together to say that we need to plug this gap by initiating these training courses. Thank you very much, Dr. Ato. Thank you, Mr. Enam Wilson, Senior Advocate of Nigeria. We're looking forward to your session. Thank you, Mr. Okechukwu Memo. And thank you to all the other facilitators who are, I saw Falabi Kuti earlier on. I saw Mr. Sobeku earlier on. Thank you all for coming. To this crew at the MBA, Sarah Ajijola, thank you very much. Wole Fuwepe at MBA IT, thank you very much. And to all of you who have taken time out to be part of this, I say a big thank you to you for attending. I think that we have to keep spreading this message because we are knowledge merchants. The only thing that we do is to peddle knowledge. And the more you know, the more you learn, the more equipped you are for the vagaries of an evolving and very dynamic practice space that requires all the skills that we have to succeed. So thank you very much for joining in today, and we look forward to seeing you all tomorrow. God bless you all, and goodbye.